James Michael Miller was charged and convicted with a firearm offense after Department of Fish and Wildlife officers located a loaded firearm in his vehicle. Department of Fish and Wildlife officers have the authority to stop people while hunting to verify compliance with hunting regulations. At the time of the stop, Mr. Miller was driving slowly down a green dot road wearing an orange sweater. Is this hunting? He argues this was an illegal stop and the charges should be reversed. Mr. Miller took his appeal to the Superior Court, but that appeal was denied. He's now appealing to the State of Washington Division III Court of Appeals. Let's get it started.
Our fourth case on the docket is State of Washington versus James Miller. Appearing remotely on behalf of Mr. Miller is Ms. Dobson, and appearing remotely on behalf of the State of Washington is Mr. Mills. Ms. Dobson, I'll introduce the panel to you. My name is George Fearing. I will be presiding. With me on the panel today are Judges Rob Lawrence Berry and Rebecca Pinnell. Ms. Dobson, please indicate how much time you'd like to reserve.
5 minutes for rebuttal, please.
Please proceed.
Good morning, Your Honors. My name is Jennifer Dobson, and I represent Mr. Miller. The issue here is whether a person who is doing nothing more than driving slowly down a bumpy green dot road during hunting season and wearing orange may be properly seized under RCW 77.15.080. This statute authorizes an officer to stop a person based upon articulable facts that they are engaged in hunting activities. The standard has been explained as requiring there be a substantial possibility that a person is engaged in hunting activities. The officer must do more than articulate an unparticularized suspicion and more than a hunch. There must be an objective justification for making this stop.
Ms. Dobson?
Yes.
To agree with your argument, do we need to disagree with our prior decision in Schlegel?
I believe you do. The dialogue between the dissent and the majority make it pretty clear that the majority is authorizing the stop of vehicles based on, there's a few slight differences in facts, but I don't think we can factually distinguish this enough from Schlegel. And so
Judge Sparks, to be fair to Judge Sparks, Judge Sparks, he was the judge here, right? Am I recalling? I think he was also the judge in Schlegel. The trial judge had to follow Schlegel, right? But we don't have to.
Exactly. Right.
Okay.
Yeah.
So are there any, one of the things I'm concerned about here with the argument is that, are there error preservation issues? This was initially raised in district court, and then it went to Superior Court and now to us. Was it ever preserved that Schlegel was wrongly decided and so therefore there's a statutory violation? Was that preserved, or was it just the constitutional argument?
It was argued, it certainly was implied in the argument. But I do believe that it was preserved, but also this court can actually should be deciding on non-constitutional grounds when it can, and under Isla Verde. And so I think that it was preserved. I would say that it was clearly preserved, but if there's a question, we're still going to get to the same position here, because you would want to decide this on non-constitutional grounds if you can.
But the question was that if it wasn't preserved, at least clearly enough, so that the trial court could have corrected the error, then we might be forced to tackle the constitutional issue, which I believe can be considered if it's manifest constitutional error. And so one way or the other, we have to deal with one of the two issues, either the non-constitutional or the constitutional one.
I would just point out, I do think that there's a concern that the trial court, both at the district court stage and the Superior Court, would have no choice but to follow Dobson. So I understand why Schlegel, I'm sorry, Ms. Dobson, we're all misstating who's who, that the trial court would have to follow Schlegel. So
that's a good point.
Overemphasizing it would have been somewhat of a waste of time. at the trial court level.
So your comment action was for her benefit.
Well, no, I just
yeah.
had an honest question, but I also think I think it's important for us to note that if we were to disagree with Schlegel, that's not saying that the trial court did anything wrong because the trial court was bound by it, but we're not.
Good point.
Ms. Dobson,
Right.
do we apply the rule of lenity?
The rule of lenity, in this case, if we're going to go back to starting from scratch, if we're going to say Schlegel is not here, I think absolutely, if it's a close call. In this case,
Is it hunting and engaging in hunting activities synonymous?
hunting and engaging in hunting activities. Well, I think that it's been defined in Walsh and so forth as more than just hunting, shooting at an animal.
Are you saying engaging in hunting activities is a broader concept than hunting?
I believe that it is. Whether it goes all the way to stopping roving vehicles when someone's wearing orange, I would say that it does not. And it's the effort to, we can look at the definition, and it's the effort to kill an animal or a bird. And so it's the question of what is effort. And it's left very broad in Schlegel, and that's what walks us into the constitutional problem.
Ms. Dobson,
Yes.
if this was a fishing case, because there's a series of things the statute addresses, and one is fishing. If there's a fishing boat that, it's fishing season, this is near fishing, would an officer be able to stop a fishing boat while it's traveling over waters? Even if at the moment there's not a net out or a line in the water? Is that a different analysis, or is it the same?
Well, would we say that a fishing boat is definitely used for fishing? And what would the facts be that would indicate that it's actually in an effort of fishing and not just transporting from one place to another? I think that
It could be that, looking at the dissent in Schlegel, one argument, I guess I can answer my own question. It's not illegal to have a net out while you're, I don't think, while you're moving a boat and actually be fishing, whereas it would be illegal to be shooting at prey or actually actively engaged in hunting while driving a car.
Right.
And having a loaded weapon in a car.
I'm sorry, that last comment, please.
Or having a loaded weapon in a car, which is the whole offense here.
Right, but the officer didn't know that when he stopped the car. You would see someone likely shooting out of the car when you stopped it, and you would stop based on a criminal offense there. And I think that's well covered by the statutes and what we have. But when you're just driving down the road, this could be a hiker, and that's not a highly regulated activity, hiking. And so Mr. Miller's actions were consistent with other kinds of recreational activities. There's nothing that distinguished him as engaging in hunting activity that would allow an administrative stop.
I guess the distinction I have that helps you but doesn't draw as broad of a brush, I'm concerned, quite frankly, at saying that someone who appears to be hunting and is walking can't be stopped because they might just be traveling. I mean, the whole thing of hunting is a little bit different, and it's not illegal to have a gun that's loaded while you're outside of a car. The distinction I have is the distinction that I think is interesting in Schlegel. It would be illegal for someone to be actively hunting while driving a car. It's not illegal to be actively fishing while driving a boat. It's not illegal to be actually hunting while walking down a path. So that to me is a distinction, is it not?
It is a distinction here. And I think that's what we're looking at here is where do we draw these lines? And if we're asking these questions, I don't think that the statute is clear enough. Then if we're asking these questions to have an administrative search, you have to have a regulatory scheme that puts limitations on manner and place of stops. And that's the problem. That's what Tarabaccia pointed out. this does not have sufficient standards to guide officers in selecting which vehicles to stop and when. And that's because Schlegel has definitely, it did not provide a narrow reading. It has a very broad reading of what hunting activities are. And
Dobson, one concern I have is the standard for reasonable suspicion, which this seems to indicate, you know, a vehicle stop is justified by reasonable suspicion, not probable cause. You can look at a totality of circumstances. Each circumstance in and of themselves may not be sufficient, but you can look at them in their totality. So, you know, wearing an orange sweatshirt isn't enough to stop someone. Driving on a hunting road isn't enough to stop someone. Driving in a hunting road during, you know, or driving on a road during hunting season isn't enough. But at what point is the combination of circumstances enough? Because I do think the state has an interest in making sure people are complying with hunting laws.
absolutely, but there has to be a substantial possibility. And in this case, we only have the driving slowly on a green dot road, which in an SUV, which is ubiquitous these days as a vehicle, during hunting season, and he's wearing orange. There's so many reasons. What we don't have is we don't have an officer saying this green dot road is primarily used by hunters. We don't have him saying that only, you know, mostly those engaged in hunting activities are the only ones who wear hunter orange. We don't have someone indicating that this type of car is consistent with hunting. We don't have someone indicating that primarily hunters drive slow when they're.
I'm concerned, Dobson, with your statement that it has to be substantial. I didn't understand the Terry stop to have that. It's just more than a hunch, reasonable, articulable suspicion that, you know, there is in this case, that the person would be engaged in hunting. It's not substantial. The statute doesn't say that. It's articulable facts.
Ms. Dobson, before you answer, you're into your rebuttal time. But please answer the question, but keep in mind time will be deducted from you in rebuttal.
Sure. So yes, that standards we bring in from sort of Fourth Amendment, and that's what is coming in here, is that it's more than a mere hunch. It can't be an unparticularized suspicion, and it has to have an objective justification for making this stop. And in this case, it has to show that it's hunting activity. We need to have more than something that is so consistent with so many other recreational activities that are not in this highly regulated context. And when we're talking about administrative stops, and we're talking about the difference between highly regulated activities and unregulated activities, it has to be very carefully drawn. And I think that's the problem here. And if there's no more questions, I'll save the rest of my time.
Yeah, we'll have you reserve your time. Thanks, Ms. Dobson. Mr. Mills. Mr. Mills, I have at least one question. I want you to assume that I'm driving on Interstate 90 in Kittitas County. I'm driving a pickup and have a gun on a gun rack on the pickup, and I'm wearing a bright orange vest. Would a wildlife officer who sees me have articulable suspicion that I'm engaging in hunting activities?
I don't believe so, Your Honor. I think the I-90 is the linchpin there. It's the same which distinguishes this case from the Teraboccia case. The fact that he had the orange on, he was driving slowly, and it was a wildlife area at the beginning of elk season is what makes this stop proper in this case.
Why else would I have an orange vest on?
Well, you may be planning to be hunting, but I think if you look at the way Walsh kind of draws the line there, when does the hunting actually begin? I mean, if you're driving
well, but there's a difference between hunting and engaging in hunting activities. Is that correct?
Yes, I would say that's correct.
And what's the difference?
The difference is, if you take the experience of a wildlife officer, they know that people aren't looking for elk to shoot on I-90 at highway speeds, whereas in a state wildlife area driving slowly, that's during hunting season, that's likely what they are doing.
Mr. Mills, I just have a hard time thinking that someone's engaged in hunting activities while driving a car where that would be a crime. So if you see someone, why isn't that just mere preparation? I'm concerned about, I understand the Schlegel decision and the dissent, but the dissent seems to make a lot of sense to me, that you might be wanting to engage in hunting activities. You might have just engaged in hunting activities, but if you're engaged in hunting activities while driving a car, we have a problem. It just seems that those are fundamentally inconsistent. And if there's reasonable suspicion that someone's engaged in hunting activities while driving a car, for God's sake, stop them, because they're shooting a gun while driving.
I understand. If you look at the what the court does say on Walsh is there's preparation does come into engaging in hunting activities in scouting, which it may or may not have been what the wildlife officer was anticipating Mr. Miller was doing. Would come into hunting activity, looking for where the elk may or may not be on this wildlife area.
It just seems, scouting oftentimes also happens while you're outside the vehicle and walking around. Given that people have a right to be free from illegal search and seizure in their vehicles, and it would be illegal to engage in hunting while driving a car in terms of what most people think of as hunting versus preparatory. I just worry about line drawing.
And you could contrast that with the idea that you've got a group of people around a tent, campfire with bunches of guns and fishing poles around. That could be more like engaging in hunting than perhaps driving even on a green dot road. It's hard to draw the line, but it just does seem that being outside the car is one of the lines to draw. It's hard to define engaging in hunting activities, but we know it when we see it.
Well, I think if you were outside the car, it'd be a lot harder. But given that it would be illegal to be engaged in hunting activities while driving, that's the problem that I have.
I don't think it's necessarily illegal to engage in what we call hunting activities while driving cars, but it's illegal to hunt. It's illegal to actually, unless you have a disability permit or something like that, to be shooting out of a car. But again, if you go back to what Walsh says, there's a lot of lead up to actual hunting. And if you take all the circumstances in this case, where he was, what he was wearing, what he was doing, it is hunting activity.
Well, there's no greater reason to think, and I understand, I am completely sympathetic with not slicing and dicing circumstances, but to think that this was evidence of preparatory to hunting as opposed to leaving hunting, I don't think, based on what you've said, that it's engaged in hunting activities if you're done with the hunt and you're leaving.
I'm not sure I necessarily agree with that. If you're leaving, I think there is, if you're leaving this wildlife area anyway, you still could be engaged in hunting activities.
How many feet away from I-90 do you have to be? That you're still on the road, you're done with hunting, and you're on this wildlife road, and once you're off the wildlife road, even though, again, it's kind of slicing and dicing.
Yeah, and I think it kind of goes back to wildlife officers. Can they support what they are doing with articulable facts? In here, I believe they can. If it's if he had left the road, it's a harder call. If you're on I-90, like Judge Fairing's example, then I think it's not even a call at all. It's just you're not engaged in hunting activities.
Do we weigh at all that, especially in the state of Washington, there's a real reasonable expectation of privacy in vehicles? Like I said, separate from once you're outside of your vehicle and you're walking around. And it's easier to engage someone in a consensual encounter when they're out hunting. But do we take that into account at all?
Well, I think you do. And what the court said in Schlegel is 77-15-080 permits brief investigatory stop under authority of law, not nothing more.
Well, a lot of people would say being stopped by a law enforcement officer, no matter how brief, is a significant intrusion into the rights to be free from search and seizure. So I don't think that there is a, well, this was just sort of real brief exception.
Well, I do understand that, but then it goes back to the administrative function of this law to begin with. Why is it there? It's to protect the state's interest and the people's interest that hunting regulations be enforced for the good of the people of Washington, and that's why there's this limit on when an officer can make this stop, when he has the articulable facts to do so. If there's no other questions at the moment, I do just briefly want to touch on the difference between this case and Taraboschio, and it goes back to Judge Faring's opening remarks, and actually in some of the things that Judge Pinnell said. Where's the limit here? Where's the line? And I think if you look at what happened in Taraboschio, and I'm probably mispronouncing that, it's weird when you spend all this time with these cases, and I realize I've never tried to pronounce the names before today.
I've experienced that myself.
In that case, I think that's a demonstration of where wildlife officers clearly went beyond the limits, and they even call out in that case that look, these officers didn't try to inspect these the fish while they were in the fishing area, which is much like the wildlife area. They waited till they were out on the road and then made a stop, and there was some antagonism going on, and that's why that clearly blew through the limit of 77-15-080, even though most of the Taraboschio analysis focuses on 77-15-096, which is commercial fishing, but I think it's a similar idea.
Mr. Mills, I'm wondering, a lot of these cases where a person's engaged in ambiguous conduct, like are they engaged in a counter surveillance of an ongoing activity? The case law, as I recall, says, law enforcement, follow them a little bit longer. So if the argument here is he might have been scouting out places, so just follow him a little bit longer. Is he slowing down more and kind of peering through and seeing if there, does this look like the right place? Instead of just saying, I think that this is hunting activities it's not too much to ask. To just say, look, rather than this person just driving along the road, not engaged in hunting activities, let's see if they're stopping and pausing.
Yeah, and I think that might go back to, perhaps there could have been a better record made of what the actual, what Officer Troutman actually did here. He said, okay, I've observed him driving slowly. I guess we don't know how long he was driving him slowly. Did observe him driving slowly, excuse me. So it goes back to the officers, not only the substantial evidence, but he can't take into account his, his training, his experience, what he.
And quite frankly, if the officer would have read Schlegel, he'd say, this is all I need. So I'm not even imputing any sort of bad faith to the officer. That doesn't mean that, we can't overrule Schlegel and there's no sort of good faith exception. But the thing is that the officer here said this is enough under Schlegel. So I'm assuming, implying that they're aware of the case law, just as the trial judge would have been following Schlegel to say, this is good enough. A law enforcement officer would have said, all I need is he's, driving on a hunting road, wearing something that looks like hunting.
Yeah, and I think that is what happened here. And I wanted to touch on the dissent in Schlegel real briefly. I think he came to this. What he says is there's traveling in a motor vehicle is not, nor can it be, engaging in hunting activities. And I think I touched on this already, that state does not necessarily does not agree with that. There is preparatory, there is scouting, there's all kinds of things that can be hunting activity. That is not necessarily hunting activity, but engaging in hunting activity. And there's no site for that or anything. So I did want to address that.
So I hear you agreeing that just traveling to a hunting spot before scouting is not hunting activities. But once sort of your argument is, I mean, because that would be the same as I-90, the same as an access road, the same as the green dot road.
Well,
If you're just traveling to there, but once you start to actually, okay, this is where I want to, get out of the car, something like that transforms it? Or are you saying as soon as you enter onto the green dot road? And if so,
Well,
why?
I think there's some important distinction between I-90 and or any other highway and driving onto a road where, okay, now I'm on a place where it's public hunting land, anyone can hunt here. And I definitely think that's one of the things the officer was taking into account. It's like, not only is it the opening of elk season, not only is this guy wearing orange, but he's in a place where not only is he driving slow, but he's in a place where anyone can hunt. Any licensed hunter can hunt anyway, and that's.
But you were saying the reason why a person's engaged in hunting while driving down this road is that they could be scouting out properties. It's not just because there has to be, does there not, a distinction between preparatory, which I could be going to Cabela's and buying my orange sweatshirt, and that's not good enough for a stop. So at what point, if the point is, and I think this might be broader than what Ms. Dobson would agree with, but say we agree with you, you can engage in hunting activities from your car, but it has to be scouting things out. Why don't you then have to have evidence that he's scouting things out, as opposed to just driving to an area where he will begin to start scout things out, or as opposed to I'm leaving and I'm just leaving?
I think it's not only scouting things out, but take into account the size of this area, looking for elk. Where is he driving slowly? Is he looking around? It's observations of the officer in the totality.
I mean,
of the circumstances.
it's troubling to me. Let's say I want to go hunting with my dad next weekend. I'm going to go drive along this green dot road to figure out what's the best spot. Am I subjecting myself to a stop because I'm just looking at going hunting next weekend?
I think an argument could be made that you'd be engaging in hunting activities. I don't know.
Why isn't that hunting activities? I'm scouting out a spot, looking for a good campsite, maybe.
And it goes back to what, is it hunting season? Or what are you wearing? Are you?
Oh, it's hunting season because I want to take my dad out next weekend. But he's getting older. Don't tell him that. And I want to make sure we're not wasting time.
And you not in what are you carrying? You may be engaging.
We don't know what I'm carrying because I'm driving in my car.
Exactly. It's possible. I mean, maybe something that an officer could articulate if he has articulable facts to say, hey, I believe this person is engaging hunting activities, and he can back those up, then yes, it's possible he could be stopped. And
your time has expired, Mr. Mills. Thank you.
Thank you.
Ms. Dobson, you have 3 minutes left. Ms. Dobson, who other than a hunter would be driving on a green dot road slowly wearing an orange sweatshirt?
Well, I think that we cited there's a site in our brief that talks about its access for camping, hunting, wildlife viewing, ATV and off-road vehicle riding. And it's designed to give access to all these different people, leaf peepers, photographers, birders.
Who's going to be wearing an orange sweatshirt?
Hopefully all of them during hunting season. This is a safety issue. We want people wearing orange sweatshirts. And we want them driving
Denver
slowly.
Broncos fans here.
I'm sorry?
Go ahead. I said we don't have any Denver Broncos fans here.
No,
I think your point is, if I'm going to go on a hike in this area during hunting season, it would behoove me to wear an orange sweatshirt so I would be more visible in case there are hunters out.
Absolutely. We cite the Washington Trails Association that specifically says you should do that. And it's a wise thing. And also driving slowly on these roads. These roads are cooperatively maintained to manage sensitive habitat. We want people traveling slowly on these roads. These are typical safety precautions that my client was engaged in. Under the state's theory,
is the facts are that this was a bumpy forest road?
there was, yes, that was in the facts. And so under the state's theory, officers are objectively justified in stopping any person wearing orange who is traveling cautiously down a green dot road in hunting season. And that is a huge broad net. And that's why it gets into trouble constitutionally, because administrative searches need to have specificity as far as manner and place. And the fact that we're having this discussion and can't quite figure it out indicates that this is not very specific as interpreted. And so unless there's more questions, we'd ask that the court reverse, even if that means deciding that Schlegel was wrongly decided.
Thank you, counsel. The case is submitted.
Based on these arguments, the court reversed Mr. Miller's conviction, noting, where an initial stop was unlawful, evidence discovered through the stop must be excluded as fruits of the poisonous tree. There you have it, folks. If you like this video, please like and subscribe to watch more Laws Evolve next week.